Good afternoon, everybody. My name is Manohar Singh, and I will be the host for this event today. I, you are here. All of our viewers are here for the Global Law Assembly Conference 2022, and I welcome everybody. Uh, we have our chief guest here, Honorable Retired Justice JR Midha, who will be delivering a lecture shortly. So, it is with great pleasure that I welcome Honorable Retired Justice JR Midha, our chief guest for today, who will be delivering a lecture to our viewers on Indian legal education. Honorable Justice JR Midha served as a judge in the Delhi High Court from 2008 to 2021, and before his elevation as a judge, his lordship has practiced before several Indian courts such as the Supreme Court of India, Delhi High Court, MRTP Commission, National Consumer Disputes Redressal Commission, to name a few. His lordship has passed several landmark judgments over the years, and he has written several books which have contributed to legal literature in a multifaceted way. I am immensely honored to have this opportunity to welcome Sir, and I'm sure that many of us will learn through His Lordship's wisdom on the topic. With this, I invite His Lordship to deliver his lecture.
Thank you, Manohar. Uh, I welcome all the participants of this on this occasion. I thank Mr. Abhivardhan, President of Global Law Assembly, for inviting me to share my views on this platform. The panel discussion which will start after this inauguration is on the topic how to make India hub of alternative dispute resolution. I had a long discussion with Abhivardhan on this issue, and I compliment him for having a vision to make India as a global hub or a global leader in alternative dispute resolution. You see, the closest example of another country becoming a leader in arbitration in the recent past is the example of Singapore. Singapore has become a hub of arbitration in the world in a very short time of about, I think, 15 years or so. I remember when I was elevated as a judge of Delhi High Court in 2008, I had the occasion to visit Singapore for a conference in June 2008. The conference was on arbitration, international arbitration, and I visited the Supreme Court of Singapore as well as the Singapore International Arbitration Center, which had recently been set up at that time. The, the old Supreme Court historical building was relocated, and a new building of Singapore Supreme Court came into existence, and the old historical building was converted into a court monitored Singapore International Arbitration Center. And from 2008, and at that stage, I had the occasion to study the rules framed by Singapore International Arbitration Center. We brought those rules here, and on the same lines, we started Delhi International Arbitration Center, which is annexed to and is monitored by Delhi High Court in 2009. And today, Delhi International Arbitration Center is one of the most preferred arbitration centers in India. But in the last 15 years, from 2008 to 2015, I had been noticing that Singapore has today become a hub of arbitration, and in dispute between two parties which are outside Singapore, they choose Singapore as a preferred destination for arbitration. The vision for today's conference is to build India as a global hub of arbitration. And it is possible. It is a very good vision. And we can draw a parallel. I was just immediately before we started this session, I was having a short talk with Abhivardhan, and I shared with him that today in the medical field, India has grown as a hub of medical treatment, particularly people from all over the world. They come to India for a surgery because the cost of the surgery in their country, number one, is very high. Number two, the dates for the surgery which they get is after many months, and at times the person suffering from the disease requires immediate medical treatment. So now question rises, what should be done, and how should we make India as a hub of alternate dispute resolution, which will include arbitration and also to a certain extent mediation. You see, my view, which I have already shared at many platforms, and I would like to again put that view here, that one of the major reasons or a blocks in our legal profession is that the legal education requires major reforms. The legal education, I'll share a very small example. You see, a law graduate, many of you must have got experience, a fresh law graduate, immediately after passing out the law degree, if he is given a case to institute or defend in a court of law, he finds difficulty in doing so. Whereas if you take the other professions, for example, a person who has completed MBBS degree and somebody falls ill in his, he can give the basic treatments and start with it. He cannot be found faulting. Similarly, in other professions, particularly if you see chartered accountancy, a person who has completed chartered accountancy, he can immediately file the returns. But whereas a law graduate who has completed the law degree finds it very, very difficult, and then he has to work under the senior advocates for a long time, and depending upon how lucky he is to get a good place to work, he grows and emerges as a good lawyer depending upon the place he works and the hard work he puts, commitment he makes to the profession after a decade or so, decade or you can say 1.5, not decade, about 10-15 years time, he he emerges and is recognized as a good lawyer. So question arises, what is the shortcoming in our legal education? You see, one of the I had a passion for being having a passion for teaching and having taught in Delhi University from 1989 to 92, and now pursuing my passion to teach post retirement in a university as a professor emeritus, and sharing my thoughts at so many platforms about the need for reform in legal education. The, the need for reform, major reform in the legal education, is that the, the legal education should be taught with, with the stress on the fundamentals of law, which requires a improvement. And also the students should be taught about integration of all the laws. We teach them about 40 to 50 laws during the law degree, but the integration and how to convert it into a, when we approach the court of law for a justice, is something which is lacking. Second most important thing for a lawyer, you see, ultimately for alternative dispute resolution, whether we go to arbitration or we go to the mediation, the arbitrators as well as the counsels, they all come from the legal profession only. Many times the senior lawyers or retired judges are appointed as arbitrators, and the lawyers pursue the matter before the arbitrator. So most important skill of a lawyer is the communication skill. How to communicate. And art of communication involves the art of listening, then art of thinking before speaking, then art of speaking, then speaking with emotions, then even with the capacity to read the mind of the person, and then not to interrupt when the other person is in the process of communication. My perception is that the people who are on the top in the legal profession, they had got the inherent communication skill from their uh, which is not attributable to the law course where they did the law and they were taught something about communication skills. They already had communication skills, so they emerged as a good counsels. But the law students by itself are not taught the communication skills at all, where it is the most important artifact of a legal profession, and a person should know the art of communicating very well. So in my this inning, I have now started teaching the communication skill to the law students. Second most important thing which is there in the legal profession is the rational thinking. How to think rationally and find an answer. I'll give a very small example. Let's see the latest case of the Aryan's bail matter. Now the law and judgments, I understand, which were cited, all relevant law and judgments cited at the lowest level and second level and the last level of High Court where bail was granted, was the same. So what made a difference? It was not a different law was cited, or a different case law was cited, or different things were cited. They all were the same at all levels. Only difference which emerged at the final stage is, number one, the communication skill. How the senior counsel communicated with the court. He was able to convince with the same thing by putting it in a different manner. And then rational thinking. So at the last stage, the same lawyer, he takes out some of the points out of the case by mastering the facts and mastering the law, which were not put it in that form in the earlier forums, which makes a difference. So even if a lawyer has got the absolute perfect knowledge of law, but if he is not able to communicate, then everything is multiplied with 0. Secondly, if he knows the complete law to the and has mastered the fact, but he does not develop the analytical or rational thinking by which he puts up the thing in a proper form, then also the things don't emerge. And this communication skill, rational thinking, as well as clarity on fundamentals of law is required not only for the lawyers but also for the judge and the arbitrators. Same skill is required there for the judge and the arbitrator to also to to proceed ahead. Now let's see how Singapore International Arbitration emerged as a global leader in arbitration. So first of all, they made their rules. The rules were made, very perfect rules were made by which there's no possibility of any arbitrator or any counsel who is who can the things beyond delay the things in any manner, or in any manner they frustrate the proceedings. There are no ad hoc arbitrations. It is all institutional arbitration. Secondly, the government there also gave a very good support system to the arbitration. So they gave a lot of incentives to the arbitrators and the lawyers who come to Singapore to conduct the arbitration. So the government gave a all-out backing to the arbitration institution, which also is one of the major reasons, to my mind, we should have required to have a government should also support the institutional arbitration to attract the parties in the foreign countries, whereas none of those parties are Indian. They should come here to have a arbitration here. One recent example of a case which all of you must be reading in newspapers these days is the Amazon case, where Amazon has got a dispute with Future Group. So, and Amazon, who had invested, I think, 1,400 crores or so in Future Group, and disputes arose between them. So the agreement between them provides for a arbitration according to the rules of Singapore International Arbitration Center. So Amazon invoked the arbitration, and the arbitration started. So in that arbitration, the Amazon filed an application for interim relief. So now the agreement provided that if there is a dispute, then the disputes will be decided by a 3-member arbitral tribunal. Out of 3, both parties will choose nominate one arbitrator each, and the 2 arbitrators will nominate a 3rd arbitrator. But if there is interim relief application filed by any party, then Singapore International SIAC shall appoint an emergency arbitrator, and that emergency arbitrator will decide the application within 15 days. So 3 days for reply, 3 days for rejoinder, 3 days for hearing. Approximately, this is the time schedule mentioned in the rules itself, and in 15 days the award will come. So in this case, the arbitrator was a former judge of the Singapore Supreme Court, was appointed as emergency arbitrator, who heard the matter, and I think within 15 or 20 days he passed the award, which in respect of which the execution was filed in Delhi High Court, and I had the occasion to deal with it. Without going into much details, the point which needs emphasis for today's discussion is that the award which was passed by the emergency arbitrator, it was one of the finest awards I have seen, where in such a short time of 15 days, and all the hearings, because the matter arose during this Corona lockdown period, so entire hearing took place on video conferencing. And within 15 or 20 days, we had an award. I think the award must be about 200 pages, but on the finest awards. So kindly see how the timeline limits are kept, how in a very professional manner the things are there, and they are able to build up the reputation of being the global leader. But this has not happened in overnight. It will require time. So, so again, my emphasis would be that in order to improve the legal institution itself, you see, out of the legal institution and legal profession, we get the lawyers, and from those lawyers we get the judges. From those lawyers and judges we get the arbitrators. From that very pool we get the lawyers who conduct arbitrations. So therefore, one way of improving is to improve and strengthening the legal education, so that after doing the law degree, on day one the student can go and argue the matter like a, a perfect lawyer. So we should, number one, we should strengthen our legal education. Then number two, we should strengthen our institutional arbitration. Number three, we should, the government should also support the system, so that this system grows and the people have incentive to come here. So it will take some time, but it is not a difficult task, and this vision, to my mind, can be completed in a period of, say, about at least 5 to 8 or 10 years. So it is a very good vision of, and very nice um, topic for today's discussion. And I am sure that during the discussion, the panelists will come out with some more suggestions as to how to strengthen and make India as a global hub. At the same time, I would also like to emphasize here that, notwithstanding all the shortcomings that we have in legal education or other thing, our justice delivery system is one of the best justice delivery systems in the world. We have an independent judiciary, and the but the whole difficulty is that the delay in the decisions is because of the number of pendency in our country is so high as compared to, if we see the population and number of judges ratio, it is so low that a judge in probably all the courses have to hear approximately 50 to 100 cases in a day, which is a very, very difficult task. The judges have to go through the files in advance and then hear the arguments and the matter on the next day, and then they have to deliver the judgments. So they have to work overboard, and the and whereas if you see the the population and the judge population ratio in the developed countries, and the number of cases which are listed before the judges in the higher judiciary, there if you find, then in no other place the judiciary, the ultimate, you can say, the number of cases heard and decided by the judiciary, as well as the quality of justice, as well as the independent judiciary, is not so strong anywhere. So I'm quite sure that, and ultimately the arbitration or ADR will flow out of this only. You see, at the moment we are only having, we are having domestic arbitration and domestic ADR, where from the arbitration start from the agreement between the parties, whereas the mediation here in India is mostly the mediation which flows from the court, and the court, after wherever they find that the matter can be resolved by mediation, they refer the matter to the court. For example, Delhi High Court has got one of the finest mediation centers in the countries, and the number of cases which are referred by the court there, and number of cases which are decided out of those referred, is so high that they are practically sharing the burden of the court, and we have a successful system. But if the mediation has to emerge as a global hub, then the reference for that mediation to the mediators has to come in such a manner, it has to grow to such a manner and build the reputation, and it will require again a very difficult task, but not an impossible task. And I'm sure that with the vision of the the outcome of the conference today, and the suggestions which will emerge from the discussion today, will give a new light to our um, endeavor to find and make India as a global hub. You see, I will also share one uh, one uh, one experience. I had the occasion many years back, before, I think it was before my elevation. I had the occasion to meet one of the directors, or I think managing directors, of a top Korean company at that stage. So in that private meeting, when the discussion was there, so that director of the Korean company, he complimented. He said India is growing as a hub in all fields. So, and particularly at that time, it is about 20, 15 years back, 15 or 16 years back. He said more particularly in the IT department, India has emerged as a global leader, and in other fields also. He said India will become a global leader. So my response, instant response, was that yes, we are emerging as a global leader, but our difficulty is population. So he said, no, I don't agree with you. He said, this is your strength. He said, this population, if you educate and train the entire population, then the entire country will grow. He said, this is your resource. He said, the many of the developed countries, they are lacking on the resource, human resource. So, and I found that yes, his suggestion was very good. Our Indian brains are one of the finest brains in the world. If you see in all fields, that how they have the entire, if you see the research work which is done all over the world, the dedication and hard work with which they do. But only one difference which he mentioned, and which I also agree, is he said those countries which have grown, the citizens of that country, when they work, they first ensure that whatever they do, the country grows, and their personal growth is secondary. Primary growth is the growth of the country. He said, whereas we find here that the people here work, so the first priority is their own growth, whether with that act the country grows or not. So, but I think if we are able to build up the if that priority changes, then India can certainly emerge, not only in ADR but in also other fields of law, and like in many IT sector we have grown, and we are the market leader all over the world. In medicine also we have grown. In so many other areas we have grown. So I think that will be one of the major reasons. So I think this is a sufficient um, thought for today, and with this I'll put rest. If there are some questions, so Mr. Manohar, if there are some questions, then we can take those questions for discussion.
No, sir. There are no questions for discussion. Uh, the viewers have not posted any questions.
Hmm.
So thank you for your views, sir. Now I will invite Mr. Abhivardhan for delivering a vote of thanks.
Hmm.
I would like to express my humble gratitude to Honorable Justice JR Midha ji. It has been a pleasure hosting, sir, and the backdoor discussions which we had regarding ADR and Indian legal education have been indeed amazing. I'd say scintillating and also inspiring. And I really wish that from this thoughtful lecture that we just heard, viewers, when you watch it afterwards, I would really wish that you would learn a lot from it. And from this, I think a good and informed discourse on Indian legal education to gauge better lawyers and arbitrators into this field of law becomes possible. I was discussing with Honorable Judge about this aspect that in India we have litigators, in India we have um, judicial magistrates, but when it comes to arbitration, it has become important that we have individuals who are distinctively and most significantly involved in the profession of arbitration and other forms of ADR. So once that we aim for and once that is also happening, I certainly and honestly believe that it would be certainly a great thing for this country, and that would drive better opportunities to seek how India can become a neutral hub of ADR in the Indo Pacific. So, with this, we conclude this special lecture. Sir, this is my thank you from the organization. It has been a pleasure to host you. And as the first panel, which is the inaugural session, to be moderated by Mr. Manohar, which will be happening at 2 p.m. Indian Standard Time. I'm sure that the speakers would really learn from this lecture and they would be able to elucidate their thoughts. With this, we end this session, and it was a pleasure to host Sir for Global Law Assembly Conference 2022.
Thank you.